Hello everyone, welcome to Skyrise Academy. Today's topic for discussion is arbitration. It is covered under GS Paper 2, Important International Institutions, Agencies and Fora. It is also under the regulatory bodies of GS2 syllabus. So why it is important? Because it is in news, the Reliance future deal versus Amazon. So let's see about it. Recently, the Singapore International Arbitration Center has issued an emergency order against the Future Group and Reliance Industries from proceeding with their deal, which was signed in August, for Future Retail to sell its retail, wholesale, logistics, and warehousing units to Reliance. So the emergency order came on the request of Amazon. Amazon went to the Arbitration Tribunal of Singapore and had this emergency order issued. So what is the background? It is just for your understanding. Amazon and Future had a deal last year in which the Amazon had acquired 49% of the stake in Future coupons. Later, in the month of August, Future Retail had signed a deal with Reliance to sell its chain wholesale business to Reliance. The deal, however, ran into the legal trouble with Amazon, right? So let us see about the arbitration process. It is an agreement in which the parties decide the following. They decide the arbitral institution, also the applicable rules, seat of arbitration. So all that is decided so that at the later stage, if any issue arises, as in the case of Future and Amazon for this case, then the parties know what set of rules are to be followed. That's why it is pre-decided at the time of the signing of deal. So in this case, Amazon and Future Group had decided to refer their disputes to the Singapore International Arbitration Center, right? So once the dispute has arisen, then what's the further procedure? First, the arbitrators are appointed. See, in arbitration, generally there are three arbitrators. One arbitrator each party appoints, and the third member is jointly appointed by the those two arbitrator or the nominees. And if they fail, then by the SIAC, right? The Singapore Arbitration Center. This process takes certain time to complete. However, this arbitration center has a provision for an emergency arbitrator to get urgent interim relief. So, in this case, the urgent arbitrator was appointed, and that arbitrator has passed this emergency award restraining the current deal. Now, is it enforceable in India? There is no express mechanism under the Indian laws for the enforcement of emergency arbitrator orders. This order from SIAC is valid for 90 days until the official arbitration panel is constituted, which will be of 3 arbitrators. So, arbitration panel is always in the odd numbers, just like our Supreme Court and High Court benches, so that they can, in case of tie, we can have a decision and it's not like a draw situation, right? In India, the act is Arbitration and Consolation Act. It has been amended recently, and it is very important to know that its salient features, so do read about that too. So generally, the arbitration award is honored by the business houses. They don't dishonor it. However, they are not legally liable to compile with it, right? The challenge is the future group cannot challenge the order passed by the emergency arbitrator in India because Indian Act doesn't have any provision for it. So the option which the future group has is either they can just go ahead with the deal and dishonor the award. It won't make a difference, but the business houses have their image to maintain internationally, and so they will go by the legal means, and the legal means is to go to the High Court in India under Section 9 of Arbitration and Consolation Act. And they can put forward their objections on why the reliefs granted by the emergency arbitrator should not be granted by the High Court. So restrain on restraint, right? Now, why has Singapore emerged as a hub for international arbitration? There are several reasons. Some of those are to avoid the rigmarole of the Indian courts, to provide a neutral ground for dispute resolution. Singapore has built a stellar reputation, right? And it follows the rule of international law. And it gives comfort to the investor also. So, India now has its first international arbitration center in Mumbai, and it is a very recent development. It has been developed like 3-4 years ago. So, it is very new and it has not built that international reputation yet. Government is pushing in that direction, but obviously it will take some more time. So, that's all. Mains point of view question can be, how can India become hub for international arbitration? What more should be taken care of? All those you need to write in the answer. Do read more about the arbitration. If you have any queries, do write us in the comment section. If you haven't yet subscribed to our channel, do subscribe it to get notification regarding important videos which will really help you in your UPSC preparation. Thank you.